You're listening to Discovery, a podcast presented by the University of Washington School of Law.
Welcome to Discovery, a University of Washington School of Law podcast where we discuss today's biggest legal topics with the law school's distinguished guests and experts from around the world. I'm John Blumster, and today we're speaking with Steve Mortinger, Associate General Counsel and Managing Attorney in IP Law for IBM. Over his past 30 years at IBM, Steve has been a part of some of the biggest advances in technology and the field of intellectual property. Among his many areas of expertise, Steve is a renowned expert on subjects including open source, social media, compliance, data, and perhaps most impressively, he can explain what blockchain actually is, which we could get into off air if we need to. But he recently joined the law school for the special event Open Access to Data and Innovation, the subject of which we'll be talking about today. And we've been really looking forward to the conversation. So Steve, thank you very much for joining us today.
Oh, thank you. Good to be here.
So first off, before we get into it, can you just tell us a little bit about your role at IBM as Associate General Counsel and Managing Attorney in the field of IP law?
Sure. It's a pretty broad-ranging role, but lots of fun things to do. I have a team of 65 attorneys and legal professionals, actually all over the world, as far away as China and as close as right next to me here in Armonk, New York. And we support all the brands, everything that IBM sells, we support. I also have particular interest in data. That's how I'm involved with this. And just as another hobby, we're working on a spin out right now, and I'm heavily involved with that as well.
Great. So before we get too far into it, it'd be great to define some key terms to kind of frame the discussion. So in the context of today, what are we talking about when we say open data? And also in this context, what are we talking about when we're talking about open data licensing?
Sure. So data can come with a lot of restrictions. A lot of times people ask me questions about privacy as it relates to data, for example. A lot of those kinds of restrictions make data much more closed. But other ways of keeping data closed are, companies or people or governments that have data that they don't make available to others, that they hold on to. There has been a lot of talk of data as sort of the next big natural resource, or data as gold. I actually take a slightly different view, even though some of IBM's positions would early on particularly would have said that. I see, thinking about the sort of spinning gold, straw into gold, that analogy, I see data as more like the straw. I mean, it has independent value, but it's really what can be done with data that is where the value is. And so people, companies, governments that are holding on to data thinking it's hugely valuable, but I don't really know how to monetize it, or I don't know how to make sure I'm getting the value out of it, or making a mistake because it gets stale. It doesn't have infinite value, but it also is only valuable when it's actually in use and being able to be analyzed for the value that it brings from aggregated analysis of data.
Right. And this topic is particularly important today, given so many different efforts, including the establishing public-private sharing of data, conversations about how we use privately collected data to benefit, the greater good, the greater citizenry. Why have these discussions been accelerating and are so important to be paying attention to?
Well, I think the COVID pandemic has really opened people's eyes to that. For example, many people were calling for easier drug tests and maybe reducing some of the restrictions so that drug tests could be done more quickly. If you reel back into how you get to a vaccination, you have to have data. You have to know, what it is that's causing a problem, what people's reactions are. And nobody was really looking at, well, how do we get at sort of the root cause of the thing that, will provide us the information we need to have better vaccines. You're seeing some talk now in Europe about that, let's open up data, let's make data more accessible. Let's figure out how we can manage the privacy restrictions on data, or work with data, even with the privacy restrictions. But I pity anyone who goes out now to try and clear large quantities of data, particularly if there's patient or medical information on it, because we did it. It's very difficult. And, even as you're going through the process, there are lots of unknowns. You'll see agreements that have one of my favorite provisions, which you'll hear me talk about a lot if you've listened to other things I've done, where it says, this data is available to you for any non-commercial purpose. Well, what's that? And why is that an important restriction? I mean, it can only be used in charities. Anytime a company uses data, you have to assume it's going to be for commercial purpose. And to address pretty much any of the biggest problems that the world has, people might want to be paid for it. And I don't think that's unreasonable. So why does everything, get limited to non-commercial reasons?
Central to this discussion about data licensing and addressing some of these questions and issues is a 2017 agreement called the CDLA, the Community Data License Agreement, which you have talked extensively about. What is the agreement, and why is it necessary to develop in regard to handling these increased data licensing needs?
That's a great question, and that's sort of like talking about your children. I was one of the people who helped to draft it, so I do feel a particular affinity for it. In 2017, well, really reel it back a couple of years. In 2015, clients and governments that I worked with started to ask the question, "Hey, what if we want to release some data? What would you recommend is the license or the document that we release it under?" And so I started to read the various agreements that were out there at the time, and none of them were inherently bad, but they had problems like the one I mentioned. It would say used for any non-commercial purpose, or it wouldn't have anything about using data for development, developing insights, running AI models. And so there were agreements, but they weren't really purpose built for data. And so I think we kind of got together with the Linux Foundation and talked and said, what could we do to help that? And how could we use an open source software type model to do it? And so we came up with the CDLA, Community Data License Agreement, as a way to try and address, how can we encourage people to put data out, and how can we more standardize the terms that people are getting and giving data under, so that, when they pick up this license, they'll know that what's in it is something that is standard and consistent and meets the needs. And so that was the whole purpose of the project. We got a bunch of companies together to work on a drafting committee and put out two versions. One is a sharing version, which is a bit more like a copyleft. If you republish the data you receive under it, it has to be under the CDLA. And the other is permissive, where you don't have to republish under the CDLA.
So why don't the same agreements that work for software work when applied to data?
Well, there are different things. And so data has a much more sort of lightweight copyright protection to it. It's only in the compilation of data that you have a copyright, not in the underlying data. And so you want to at least consider that. It's not coded, and put together in a format in the same form. Sometimes it's pulled together from all kinds of disparate places. And so you want to consider that. But I think most importantly, the two things I mentioned, which is, you want to make sure that you understand how it can be further used. So software doesn't have this convert it from one thing to another, to convert from data to insights as data does. And you want to specifically think about that, because what obligations and rights do you have with the insights that you create from data? And I mentioned before the commercial versus non-commercial, although I don't think you see as much of that in software licenses. So they're different things. It's sort of like, why don't you sell a tractor under an agreement for buying seed, right? Well, they're both farm related things, but they're not the same thing.
So I guess backing up, when you're talking about a company figuring out how best to release data for use, what are some of the potential uses of data in regard to the public, benefiting the public and approaching addressing some of the needs there?
Sure. Well, as cities are looking to expand, right? If they make available data on building permits, new sewage lines, new water lines, new traffic patterns that are being developed, new roads, they make that available, then companies interested in putting in restaurants, daycares, coffee shops can all avail themselves of that and be ready there to meet the needs of the citizens early rather than late. And so there's a lot of benefit to people to sharing that type of data. And again, it is commercial, that you can't get, from not having that type of awareness. Likewise, you can take a lot of disparate types of data on weather, on historic crop analysis, soil capabilities, et cetera. And you can, advise farmers as to where best to plant, when best to plant, when best to harvest, just based on historic data. And no single piece of that data does the same thing. I mean, if I know the average rainfall on June 3rd through a decade of days, it doesn't tell me much. But if I can combine that with some of those other elements I was talking about, we start to have some really valuable information.
It really is incredible, the potential and everything that's happening. I mean, it really is an amazing field. Anytime we talk about data, the issues of privacy always come up. So does the CDLA cover privacy? And if not, what does?
Well, so the CDLA specifically says in the FAQs, if you have data with privacy issues, it shouldn't be included under this agreement. That's not the purpose of the agreement. I won't get into specific other agreements. There are ways of doing that involving anonymizing data and sort of taking the elements that might have some particular privacy issues in them out. But I'm not a privacy lawyer, so I probably border on malpractice if I try and give you too much advice in that area. But it is obviously harder where there's a lot of personal data involved. That doesn't mean that data isn't important. In fact, as I mentioned on the COVID analysis, some of that data is the most important data to have, but also the one with the most hurdles to get.
When it comes to figuring out data licensing agreements and how this is evolving, even so rapidly now, what did we learn from software licensing and the proliferation of agreements that really exploded? Some of which that we spoke about previously that could apparently get a beer bought for you, which is which is pretty interesting.
Right.
And how can we, I guess, guard against some of the issues that we ran into with the proliferation of software agreements?
So I think, back to the concept of what is open data, one of our speakers in the session last night was talking about Richard Stallman from the GNU project, Free Software Foundation. And he liked to say, when he was talking about free software, that he was talking about free like liberty, not free like beer. And I think that's what we're talking about with data as well. I don't have a problem with people being able to, charge for the work they put into creating data, but certainly, you don't want data to be dead-ended. And as we grow with the number of agreements there are that deal with data, the problem is the more opportunities there are for people to create some crazy terms and conditions that may not work well. Attempts to reduce the number of open source software agreements that the Open Source Initiative has undertaken. I think there are still 70 open source software licenses at least now. That's a lot. And there might be an argument for a handful, maybe even two handfuls. 70, that seems like an awful lot of agreements, and there must be a lot of crazy things being addressed. The example that I gave you the other day was, being a lawyer who supported teams doing software, open source software work, they would bring me sort of the oddball terms and conditions they would see. And, they would have things like, if you ever meet the software developer, you agree to buy him or her a beer. And they'd come to me and say, can we agree to this term and condition? It's like, okay, just have the money ready to buy them a beer if you ever have them knock on your door. I'm fine with it. And there would be ones, sort of the old Google expression. Some of them had provisions in it that said, you can use this software, anytime you want, any way you want, as long as you commit that you will use it only for good and never for evil. And my clients would come to me and say, can we agree to this? And it's like, well, what do you plan to do with the software?
Like if you have to, if you have to ask, it raises some flags.
Right.
What are some of the challenges that need to be addressed in terms of data availability, like you mentioned towards the top, if we are truly trying to fulfill that mission of leveraging data for public good?
Right. I mean, I think, first off, companies and governments need to really consider why they aren't releasing certain types of data. If they don't have a reason other than maybe the hope that there's a lot of money to be made for selling it at some point, I would really ask them to reconsider that, because again, the value is in using the data, and they'll find that as well. I mean, the more that the data is opened up, the more there's opportunity for value. The next thing in terms of when data is opened up, I've talked about a couple of things that are impediments. Another one, oftentimes when you'll see governmental mandates to make data available, it might be available, but it might not be usable. And what do I mean by that? We've talked about some of the issues with privacy, questions. Another is, companies or governmental entities might put up data, but put it up under agreements that are so horrible that it's available but it's not usable because it has terms and conditions that basically say nobody can use it for anything. And I guess the last is format. And I know format is probably the least sexy thing to be talking about, but a standardization of formats so that when people put up data, it's in a form that can be easily pulled down and used. For example, PDF files, not good. They're not usable. So if we put up data in ways that it can be readily accessed and readily used, that's all the better.
So as we're looking toward the end of the pandemic and beyond, what should we be paying attention to right now in the space when it comes to data and the evolution of how we approach licensing and use?
Well, I'm watching Europe, and again, I'm not a privacy lawyer, but they really are considering some creative things about how to make data available, even data with privacy restrictions, make it available in sort of a commons, but still accommodate some of the concerns about privacy, so we're not violating people's privacy rights, but still having the ability to use anonymized, aggregated data in ways that benefits the public. I think I've mentioned before, and I'm sure others have as well, people will readily click through and give away personal information to watch a video of a cat playing with a ball of yarn. They will. And somehow we aren't given the opportunity. For example, let's say I'm okay with people using my personal information if it helps to develop a COVID vaccine. Why isn't there a way that people can say, I'd like to opt in for this limited purpose to allowing certain amounts of my data, and maybe we could even specify what that is, to be used? If there are ways that enable people to allow data to be used for the public good, it seems to me that's more of a priority to me than watching a video of a kitten. Although fun, it's probably not of the same level of importance, but I have the option to figure out if I want to give my data, my personal information away for that. But I don't have an option to figure out how to give my personal information away in a controlled way for the public good.
I mean, watching a cat playing with a ball of yarn, I mean, who doesn't love that?
Good stuff, yeah.
Yeah. Finally, for the law students among our listeners, what would be your pitch for why intellectual property, and especially in this context, is a field that they should be strongly considering being a part of?
Well, it is clearly the future. I mean, there's no doubt that a lot of the problems that we're trying to solve in the world, have a strong element of intellectual property to them. It has the opportunity to deal with, things like AI, things like data. There's patents. There's really never a dull moment. It's a great profession. It's certainly one where I think there's a lot of opportunity to be involved with some of the most interesting things you can imagine.
Steve Mortinger is Associate General Counsel and Managing Attorney in Intellectual Property Law for IBM. He recently joined the law school for a special event focused on what we spoke about today, open access to data and innovation. You can find more links to today's topic over on our podcast page at law.uw.edu. Steve, thank you so much for taking the time. This was a lot of fun.
Thanks. It's been fun.
Discovery is hosted by John Blumster and produced by Greg Olson. Additional voiceover work by Ben Gonio, with original music by John Blumster. Discovery is recorded in William H. Gates Hall at the University of Washington School of Law in Seattle, with the support of Mario L. Barnes, the Tony Rempe team. For more, visit law.uw.edu.